In this lecture, we shall begin our discussion by treating alienation of family property in Ghana. Alienation of family property. And over here, we are referring to family immovable property. For example, family land or a family building in Ghana. Now, as a general rule, or at least best practice, as a general rule, or at least best practice, before a family property or family land will be alienated, a family meeting should be convened in order to secure the necessary consents required for a valid alienation of family land. And for this general rule, I refer you to the case of Allotey versus Eshon. Allotey is spelled AWORTCHIE versus Eshon, ESHON, 1872. Refer to Saba, the book by John Mensa Saba, Fancy Customary Laws at page 170. That is where this general rule is captured. That as a general rule, or at least best practice, if you have to alienate family property or family land, then a family meeting should be convened in order to secure the necessary consents required for a valid alienation of family land. Now, how do we then alienate family land? Who is supposed to sign the deed or documents? Who are supposed to be the participants in a transaction where family property or family land is about to be alienated? So over here, the general rule is that in order for family land to be validly alienated, then it must be the head of family, together with the principal members of the family. They are the ones who must participate in the transaction for the valid alienation of family land. The head of family, together with the principal members. And on this, I refer you to the case of Allotey versus Abrahams. Allotey versus Abrahams. Allotey is spelled ALLOTEY versus Abrahams. 1957, 3 West African Law Report at page 280. And this is what ALIENATE said in relation to the persons that must participate in order for a valid grant or valid alienation of family land to be made. So in Allotey and Abrahams, this is what ALIENATE said at page 286 of the reports, and I quote, according to native law and custom, it is only the occupant of the stool or the head of family who is entitled, with the consent and concurrence of the principal elders of the stool or family, to alienate stool or family land. There can be no valid disposal of stool or family land without the participation of the occupant of the stool or the head of family. But there can be a valid alienation of stool or family land if the alienation was made by the occupant of the stool or the head of family with the consent and concurrence of some, but not necessarily all, the principal elders of the stool or family. The occupant of the stool or head of family is an indispensable figure in dealing with stool or family land. Quote ends. This is Allotey in Allotey and Abrahams. He's telling us that before you can validly alienate family land, it must be the head of family acting with the consent and concurrence of the principal members of the family. And that the head of family is an indispensable figure in dealing with family land. And Allotey also mentions that we do not need to have the consent of all the principal members. And that once the head of family is present, it may be enough to have the consent of some of the principal members. This is Allotey in Allotey. This is Abrahams, 1957, 3 West African law reports. And he's saying that before you can validly alienate family land, the head of family must act with the consent and concurrence of the principal members of the family. Now, the next question is this. When the head of family acts to alienate family land, but he does so without the consent and concurrence of the principal members. Now, the question is, what is the effect of such a transaction? The head of family acts alone. He doesn't secure the consent and concurrence of the principal members of the family. What is the effects of such a transaction? Is the transaction void, such that the person who was acquiring the rights will end up acquiring nothing at all, or the transaction will be voidable? And if it is voidable, what we mean is that would it be valid unless and until the family takes steps to have the transaction set aside? That is the question now. What is the effects of the alienation of family land done by the head of family alone without the consent and concurrence of the principal members of the family? Now, the law is that when the head of family acts alone and he doesn't secure the consent and concurrence of the principal members, so the head of family acts alone, then the transaction is not void, but the transaction is voidable. When we say it is voidable, it means that the principal members of the family can act timelessly to set aside the transaction. Set aside the transaction. Now, this rule has been stated in the case of ADJEI versus Mensah. ADJEI is spelled BEYAIDEE, BEYAIDEE versus Mensah. Mensah is spelled MENSAH. You see this case in 1878 in Saber's book on customary laws at page 171. And this is how it has been captured, and I quote. Now, although it may be, and we believe it is the law, that the concurrence of the members of the family ought to be given in order to constitute an unimpeachable sale of family land, the sale is itself not void, but capable of being opened up at the instance of the family, provided they avail themselves of their rights timelessly and under circumstances in which, upon rescinding of the bargain, the purchaser can be fully restored into the position in which he stood before the sale, and the quote ends. And so you see that when the head of family acts alone, the transaction is not void, but the law treats it as being voidable, meaning the members of the family can act timelessly to have the transaction set aside if they act timelessly, and they can fully restore the purchaser into the position in which he stood before the sale. And so, if you can give the purchaser's money back to him and any expense he has incurred on the land, then you can rescind the bargain. Now, this rule that has been stated in ADJEI versus Mensa has been reaffirmed in the case of Manko versus Bonsu. Manko is spelled M-A-N-K-O versus Bonsu, B-O-N-S-O, 1936, 3 West African Court of Appeals at 625. And also in the case of Yawoga versus Yawoga. Yawoga is called Y-A-W-O-G-A versus Yawoga, 1958, 3 West African Law Reports at page 309. And also in the case of ADJEI versus APPIAGYEI, ADJEI versus APPIAGYEI, ADJEI is spelled A-D-J-E-I versus APPIAGYEI, A-P-P-I-A-G-Y-E-I, 1958, 3 West African Court of Appeals at page 401. And this is what the Court of Appeals said. In this case of ADJEI and the APPIAGYEI, this is what the Court of Appeals said at page 404 of the report. And I quote, "A sale by the head of family without the assent and concurrence of the rest of the family is not void. It is voidable at the instance of the family, but the court will not avoid the sale if it is not satisfied that the family has acted timelessly and with due diligence, and that the party affected by the avoidance of the sale can be restored to the position in which he stood before the sale took place." And the quote ends. And so, as you can see, this rule that has been stated in ADJEI versus Mensa as far back as in 1878 has been clarified by the Court of Appeal in the case of ADJEI versus APPIAGYEI in 1958. And this is what the Court of Appeal has said. That the head of family, when he acts alone, it doesn't make the transaction void, but it makes it voidable, provided the family acts timelessly and they can set it aside and restore the purchaser fully into the position he stood before the sale took place. And so the Court of Appeal went ahead to clarify the conditions that must be satisfied by the family when they are seeking to avoid a transaction in which the head of family acted alone. This is what the Court of Appeal said. But one, the person seeking to set aside the transaction must be the proper person to represent the family in a suit relating to family land. Must be the proper person to represent the family in the suit relating to family land. Number 2, that the members of the family were wholly ignorant of the transaction. They were wholly ignorant of the transaction. And so if we can show that the members, you were there, you collected some of the money, then, or you are aware of the transaction, you cannot come later to say you want to set aside the transaction. The third point, that the family had not by any conduct subsequent to the date mentioned acquiesced in the transaction. Acquiesced in the transaction. And so if the head of family acted alone, and they have gone to put the purchaser into possession, and you, the remaining members of the family, you were the ones who even assisted that purchaser to fence the place, you helped them to build a foundation, you helped them bring in a chip of sand and stones. Your conduct, even though you did not participate in the transaction, your conduct will show that you have acquiesced in the transaction, and you will not be allowed to come later to say that you want to set aside the transaction. That's the third requirement. So we have number 1, that the person seeking to set aside the transaction must be the proper person to represent the family in a suit relating to family land. Number 2, that the members of the family must be wholly ignorant of the transaction. Number 3, they must prove that the family had not by their conduct acquiesced in the transaction. Number 4, the family must prove that they have acted timeously and with due diligence. And number 5, they must prove that the defendant could, on a declaration by the court avoiding the transaction, that the defendant could be put in the same position in which he stood before the transaction. So that means that you can give the member of the family, the purchaser, the money that he expended in the acquisition of the land. And maybe if he has spent some money in the foundation, you can give him his money back. Now, on who does the burden lie in establishing that the consent of the principal members was not sought? If you read the case of Atta, A-T-T-A-H, versus AIDU, A-I-D-O-O, and others, reported in 1968 Ghana Law Reports at page 362. APPIAGYEI, as he then was, says that it is the plaintiff or the one who is seeking to set aside the transaction. He is the one that has the burden to prove that the consent of the principal members or the rest of the members was not sought before the alienation was done. The next question, we have seen that if the head of family, that before you can have a valid alienation of family land, it must be the head acting with the principal members of the family. We have seen that in the case of Allotey and Abrahams. We have seen also in ADJEI and Mensa that if the head does not participate, if the head participates in the transaction alone, but he doesn't seek the consent of the principal members, the transaction is not void, but is rather voidable. So ADJEI and Mensa that if the head participates alone without the consent of the principal members, it made the transaction voidable. And also, we have seen that the family can have it set aside if they act timeously. Now, what if the head acts? What if the head does not participate in the transaction? So let's say the principal members alone go, and then all of them, all the principal members, they go and then they go and alienate family land. What is the consequence of it? The law is that where the head does not participate in the transaction, the alienation is void ab initio. The whole alienation is void ab initio. If the head of family does not participate in the transaction, the whole transaction is void ab initio. And you see this principle laid down in the case of AGBLO versus SAPO. AGBLO is spelled AGBLOE versus SAPO. SAPPOR. 1947, 12 West African Court of Appeals at page 187. And this is what the court said in AGBLO versus SAPO. AGBLO versus SAPO. The court said that, and I quote, the principal members of a family cannot give any title in the conveyance of family land without the participation of the head of family. The head of family may be considered to be in a position analogous to a trustee, from which it follows that it is quite impossible for land to be legally transferred and legal title given without his consent. The alleged deed transferred was therefore void ab initio, and the respondents derived no right of absolute ownership by virtue thereof, and the quote ends. So as you can see, if you are going to acquire family land, you must make sure that the head of family is a participant in the transaction. He's a sine qua non in the transaction. He is an indispensable figure in the transaction. If the head does not participate in the transaction, then as we have seen in AGBLO versus SAPO, the whole transaction will become void ab initio. So the purchaser will acquire no right whatsoever under the transaction. And so, from what we have done so far, we have remembered and mentioned that as a general rule, according to Allotey versus ADJEI, a family meeting must be convened in order to secure the necessary consents for a valid alienation of family land. We've also mentioned that as a general rule, for a valid alienation of family land, according to ADJEI, in Allotey versus Abrahams, it must be the head of family acting with the consent and concurrence of the principal members of the family. And in Allotey and Abrahams, ADJEI mentions that it is not important to get the consent of all the principal members, and that it is enough if we get the consent of some of the principal members. We have seen in APPIAGYEI versus Mensa that if the head of family acts alone, the transaction will not be void, but will be voidable and can be opened up and set aside at the instance of the members of the family, provided they act timeously, and they can fully restore the purchaser into the position in which he stood before the sale took place. We mentioned that the rule in APPIAGYEI and Mensa has been clarified by the Court of Appeal in ADJEI versus APPIAGYEI, where the court reaffirmed that when the head of family acts alone, the transaction is not void, but the family can reopen the transaction and set it aside if they act timeously, and they can restore the affected party into the position in which he stood before the sale took place. And most importantly, we mentioned that if anybody would want to reopen the transaction and have it set aside, he must show that the family had not, by their conduct, acquiesced in the transaction. He must show that the person seeking to set aside the transaction was the proper person to represent the family in a suit relating to family land. And we have seen that the purchaser too must be capable of being fully restored in the position in which he stood before the transaction. We have seen in ACA and ADU that the burden of proving that the consent of the members of all sorts lies on the party who is seeking to decide the transaction. And we saw finally in the case of AGBLO versus SAPO that when the head does not participate in the transaction, then the whole transaction becomes void ab initio. Now the next question. What is the kind of interest that a family can create out of their family land? Can the family grant a freehold in family land? Now the answer to this can be found in section 9 of the Land Act of 2020, Act 1036. Section 9, subsection 2 of the Land Act of 2020, Act 1036. And this is what it says. That a person shall not create an interest in or right over any stool or skin or clan or family land which vests in that person, another person, or body of persons, a freehold interest in that land, howsoever described. A person shall not create an interest in or right over any stool or skin or clan or family land which vests in that person, another person, or body of persons, a freehold interest in that land, howsoever described. And so what it means is that even though family can own lands, when they are granting the lands, they cannot grant a freehold interest in the family land. The reason is that if you look at section 9.1 of the Land Act, it says that a stool or skin or clan or family land shall vest in the appropriate stool or skin or clan or family on behalf of or in trust for the subjects of the stool or skin or members of the clan or family in accordance with relevant customary law and usage. So when you are a head of family, the land has been vested in the family as a trustee for the whole family. We don't want you to be dissipating land so that future members of the family will not have any land at all to deal with. So now, creating of a freehold interest in stool land, howsoever described, has been prohibited under section 9.1 of the Lands Act of 2020, Act 1036. And for those of you who are interested, you can look at Article 36 Clause 8 of the 1992 Constitution, which recognizes that ownership of land carries a social obligation, that the state shall recognize that ownership of land carries with it a social obligation to serve the local community. And in particular, the state shall recognize that the managers of public stool, skin, and family lands are fiduciaries charged with the obligation to discharge their functions for the benefit, respectively, of the people of Ghana, of the stool, skin, or family concerned, and are accountable as fiduciaries in this regard. This is the 1992 Constitution, Article 36 Clause 8, saying that the family, when the family has any land, they shall be fiduciaries, and they shall be accountable as fiduciaries. So the provision in section 9 of the Land Act is in line with Article 36 Clause 8. But bear in mind that the provision in section 9, subsection 3, provides that even though we have prohibited the creation of freehold interest in family land, it does not take away the inherent right of a subject of that family to the usufructuary interests in the vacant portion of family land. It means that your inherent right as a member of the family to acquire a usufructuary interest, which you can acquire for an indefinite period. Section 9.3 recognizes that if you are a member of the family, you can still have your usufructuary interest, meaning that we do not have an absolute prohibition of a freehold interest in family land. It means that members of the family, their inherent right to acquire freehold interest, they can still acquire that one under customary law by acquiring the usufructuary interest. And that is recognized by section 9, subsection 3 of the Land Act of 2020, Act 1036. Then finally, there's this case of Republic versus Regional Lands Officer, who ex parte KLUDZE versus Regional Lands Officer, who ex parte KLUDZE, reported in 1997-98 One Ghana Law Reports at page 1026. Please, this case held that freehold interests can be created in family lands, and that an order of mandamus was granted to compel the Regional Lands Officer to create a freehold interest in family land. Please, this is not bad law. It is not bad law because of Section 9, subsection 2 of the Land Act, which prohibits the creation of freehold interest in family land. So remember that the Republic versus Regional Land Officer, who, as per the KLUDZE, reported in 1997-98 One Ghana Law Reports at page 1026, is not bad law, because now we cannot create freehold interest in family land because of Section 9, subsection 2 of the Land Act of 2020 at 1036. But remember the exception, that under Section 9, subsection 3, the inherent right of a subject of a family to acquire a usufructuary interest is still recognized as an interest in family land. You can check Section 5 of the Land Act of 2020 at 1036 to see the description of what the usufructuary interest is. That's Section 5. Subsection 1 says that the usufruct is an interest in land, A, which is acquired in the exercise of an inherent right by subjects or a member of a stool or skin or family or clan which holds the allodial title through the development of an unappropriated portion of the land of the stool or skin or family, or by virtue of an express grant. So members of a family have an inherent right to develop an unappropriated portion of family land and to acquire the usufructuary interest if they engage in that act. And the incidence of the usufructuary interest is that it is of indefinite duration. So that is why we are saying that even though Section 9, Section 2 prohibits the creation of freehold interest in family land, it doesn't take away the right of a subject of a family from moving onto an undeveloped portion of family land to develop same for his use. And when he does so, he would acquire the usufructuary interest, which would be of indefinite duration and can be even alienated. This brings us to the end of our discussion on alienation of family land in Ghana. We know the persons who can alienate, and we know the interests that can be created out of family lands. And we have seen the prohibition in creation of freehold interest in family land in Ghana. And we have seen how the case of Republic versus Regional Lands Officer, who, as per the KLUDZE, is now bad law. And we've seen now how even though there's a prohibition in creation of a freehold interest in family land, we've seen that the inherent right of a member of the family to acquire the usufructuary interest has been preserved. In our next lecture, we shall deal with the litigation in respect of family land. Litigation in respect of family land. How do we litigate, and who has capacity to alienate, to litigate over family land? Is it the head of family? Can the principal members go and sue? We'll look at that. And we also treat the appointment, removal of head of family. And then we'll discuss the accountability of the head of family. Thank you.